This meeting is being recorded.
All right, happy Tuesday, everyone. Thank you so much for being with us here today for the fourth and final installment of our Fair Housing Training Series. It's with great excitement and in great sadness that I say that. I say that because it's been an awesome training series with two awesome speakers, and obviously sadness that this is going to be the last one of this. You never know in the future what we may bring to you. So with that being said, thank you all for being here and coming to learn about fair housing, acknowledging, addressing, and attacking disparate impact discrimination. This is such a great subject to close our fair housing training series on because, you know, it's very justice forward. Not the whole series has been, but this is something that I think is a really great note for us to close this entire series with, and I hope that you all feel the same. So housekeeping, this is being recorded. I'm sure you've heard the numerous announcements saying it's being recorded, and you will get a copy of this recording within 24 hours of this event. This was also approved for CLE credit, one general CLE and one bias elimination CLE. So I will be providing that CLE code at the end. I'll pop it into the chat, and it will also be included in the email from Zoom that you receive within 24 hours with the recording and the materials. Finally, please put your questions into the chat or the Q&A. Today, I believe Christina, our speaker, is going to be helping me monitor the chat a little bit. So Christina will be able to address your questions in live time or bring them up, you know, whenever is the appropriate time. So put them in there as you're thinking them. One of our favorite things, I think I can speak for everyone about our audience that comes to these fair housing training series, is your involvement, is hearing what you have to say, is learning together, you know, as a community. So please, questions, answers, thoughts, whatever it might be, into the chat or the Q&A. So with that being said, this is my last time in this series to introduce our amazing speakers. I'm so happy to have them here, and I'm so happy that we all get the chance to learn from them. So first up, we have Joseph Cordova. He's the attorney and fair housing project manager at Florida Legal Services. Joe spent the first 2 years of his legal career as an Equal Justice Works Fellow, practicing community lawyering for immigrant families. He has since transitioned into efforts such as housing discrimination, enforcement, and outreach, where he manages Florida Legal Services Fair Housing Initiative Project via the HUD-funded FHOI and EOI programs. He has a bachelor's degree from DePaul University, a master's from the University of Colorado in Public Policy, and a JD from the University of Florida Levin College of Law. He has over a decade's experience working with vulnerable populations, performing community development services, and was recognized by the Levin College of Law with the 2018 Helen Gibble Bleachman Memorial Community Service Award. We also have with us today Christina Benitez. She's the Fair Housing Outreach Coordinator at Florida Legal Services. Christina is a graduate of Ohio State University. Over the past decade, she has worked in a wide variety of professional capacities in both private and public sector. Christina has experience serving vulnerable populations through her extensive volunteer work in her community. Her work focuses on providing support for the Fair Housing Project by conducting fair housing outreach and education in North Central Florida. So with that being said, I'm going to turn it over to our speakers. Thank you all again for being here with us today, and looking forward to learning from you, Joel and Christina.
Well, thank you so much as always. And yes, this is our fourth and final one in this series, but we hope to be back in front of you all again someday. But we're definitely going to dive into this one and wrap up our conversation on fair housing. And as Alexis mentioned, Christina is going to do her best to pay attention to the chat box and interrupt me whenever it's necessary. So let's make sure we have as informal as an interaction as possible throughout this presentation. But I am just going to dive in and start to run with it. So today we're talking about fair housing. We're going to do a deeper dive into the concepts of disparate impact. This is extremely important when we talk about fair housing because as we learn in our work, a lot of the times, a lot of the stories that people bring to our attention, we can't actually see in the fact pattern where the discrimination or where the violation of the Fair Housing Act occurred. but we know it's there. And a lot of times it's in there because it's in there via disparate impact, which is why it's so important to understand what this concept is and how it applies to fair housing. So before we dive straight into fair housing, disparate impact. I'm just do a very quick, brief recap. If this is your fourth time joining us, we won't spend a whole lot of time on this, but just a reminder, the Federal Fair Housing Act prohibits discrimination in housing related to transactions because of race, color, religion, national origin, sex, disability, or familial status. Remember those 7 protected classes, especially as we talk about disparate impact. Because a lot of times people bring us stories, and if you're working for a legal aid organization, you're going to hear stories. And I'm going to give you an example that we're going to kind of keep coming back to throughout this discussion. Someone's going to come to you and say, I have an issue where my housing provider is making me sign a form that says I am I have lawful immigration status in the United States. Is that a violation of the Fair Housing Act? Well, looking at those 7 protected classes, immigration status is not one of them, but national origin is. So we have to connect the dots, or we have to draw a line from immigration status to national origin, or possibly race, or possibly religion, from immigration status to one of those protected classes. And we have to find a way to do that through disparate impact. And that's what we're going to walk you through today. And so fair housing opportunities must be maintained throughout the relationship with the person seeking the housing or housing service. This is not a one-time interaction. So it's not just simply a denial of housing at the application stage. Sometimes it's a denial to renew, or a denial to provide housing services, a denial to allow you to entertain or enjoy common spaces, or sometimes the lease is enforced differently against you than it is against others. So it's not just a one-time denial of housing or acceptance, and that's that. Sorry, my slides are insisting that I switch. There we go. Let me go back up. Okay, so one recap also we want to talk about, we've talked about in the past about disability-based discrimination. Disability-based discrimination often refers to what's called the reasonable accommodation. Under the Fair Housing Act, a reasonable accommodation is a change, exception, or adjustment to a rule, policy, or practice, or service. It's not allowing someone to violate the rules, it's allowing an exception or a carve out inside the rule to accommodate a disability. When we talk about disparate impact, keep an eye on these ideas of policies and practices. A lot of times housing providers will fall back on, we're not making a decision, we're just following policy, or this is our common practice. I'm sorry it affects you, but it applies to everybody. If you're unwilling to make certain accommodations based on disability and you're standing behind a policy or a practice, there's a chance that that decision to maintain the practice is actually a disparate impact violation of the Fair Housing Act. So the Fair Housing Act makes it unlawful to refuse to make reasonable accommodations to rules, policies, practices, and services, when such accommodations may be necessary to afford persons with disability an equal opportunity to use and enjoy a dwelling and public and common use areas. So again, it's not just about denying housing, it's denying the opportunity to equally enjoy your housing. Okay, that's what we're talking about with the Fair Housing Act. So if a housing provider says no to a reasonable accommodation, such as an emotional support animal or a service animal, sorry, it's above the weight limit. This is our policy, this is our practice, sorry, we can't do anything about it. You're denying equal opportunity to use and enjoy the housing, just as everybody else would. You're allowing someone to level the playing field. What is a reasonable modification? Similar to a reasonable accommodation, a reasonable modification is a structural change made to the existing premises, occupied or to be occupied by a person with a disability, again, to afford such person full enjoyment or equal enjoyment of the premises. So reasonable modifications can include structural changes to interiors and exteriors of dwellings in the common and public use areas. And under the Fair Housing Act, it's prohibited discrimination includes a refusal to permit at the expense of the person with a disability reasonable modifications of existing premises occupied or to be occupied by such persons. Again, if it's to afford them equal enjoyment, full enjoyment of the premises. So in private housing, The housing provider needs to say yes, but they are allowed to say that you have to pay for it. But again, today we're talking about disparate impact. We want to find those spaces where they're saying no and they're saying it's because it's our policy. Okay, when does that policy need to be stretched out a bit? When does that policy need to be re-examined? When that policy is implemented, who is it really affecting? So when is it okay to refuse a modification? A housing provider can deny a request, reasonable accommodation modification, if that request is not related to the disability. Okay, so if a tenant, let's say, has a mental health disability and they're asking for a wheelchair ramp to be installed, you have to have a nexus between the disability and the accommodation or modification being requested. So a landlord can deny that. The reason why that's important to understand is that sometimes, and Christina and I have heard this as we've done these types of presentations directly to housing providers, sometimes they tell stories and they don't say it from a place of cruelty or intentional discrimination, but they'll ask questions and say, we have this request, it's from someone with a disability, and I got to be honest, they told us what the disability is, and I'm just not really even sure that makes sense to me. That's when we put up the stop signs. It doesn't need to make sense to you. If it's not obvious that it's not related, my example, I suffer from depression and I need a wheelchair ramp, that's obvious. Those two don't go together. But when somebody gets into the details of someone's disability and says, really, that kind of disability, I'm not really sure you need what you're asking for. Don't go down that road, okay? If you're a housing provider, if you can imagine a world where someone with that disability needs that accommodation, that means you're living in that world, okay? You don't have to imagine much further. You're in it, okay? You can also deny or refuse a modification or an accommodation if it would impose an undue financial and or administrative burden on the housing provider, or it would fundamentally alter the nature of the housing provider's program. This is, again, where we tell housing providers all the time, you need to be flexible with that term burden. Is it extra work? It might be. Is it a burden though? Probably not. Yeah, a good example is, let's say, this is an example we've used in our presentations in the past. Let's say somebody has a developmental disability and they can live independently, but they need assistance from a parent to help pay the rent and stuff like that. And so the tenant asks the housing provider, can you include my mom on our communications because she helps me with my independent living? And the housing provider says, no, we don't do that for everyone else. That's not a burden. That's just CCing mom on emails. That's not an undue burden, okay? As far as undue financial burden, again, in private housing, you can pass the cost on to the tenant. So there really won't be a financial burden, okay? As far as modifications though, you can deny a modification if it's an undue structural burden. This is a historical building. It was built 100 years ago. Adding what you want us to add, it literally cannot be added to this building. We're going to have to knock down walls, load-bearing walls, the frame, everything like that. You can say no at that point, okay? But we're really talking about a burden. We have that's the term being used, not a minor frustration, a burden, okay? Now, federally financed housing or government subsidized housing, they have different expectations when it comes to undue burdens. In subsidized housing, you do not pass the costs on to the tenant. The government program has to pay for it themselves. So we talked about this. What is an undue burden? I explained that. I'll move past this slide here. So let's go ahead. Let's dive into disparate impact. Okay, so what is it? So disparate impact is when a policy is not discriminatory on its face, but it results negatively on one protected class more than another. So the rule or the policy or the practice applies to all, but it adversely affects some at a higher rate. And those some that it affects, they all happen to belong to the same protected class. Okay, so here's the example we're going to use throughout this process, but I have other examples I'm going to draw from as we talk. Let's say you have a housing community that says you must have a full-time job to qualify for housing. That's the rule. It applies to everyone. I don't care what race you are, national origin. I don't care what protected class status you are. Everybody has to have a full-time job to qualify for housing. Now, in reality, in the world we live in today, people with disabilities are more likely to be people with part-time jobs. I personally, back in a former life, long time ago, I used to manage a federal program that dealt with WIPA and the Ticket to Work program. So this was SSDI and SSI benefits planning. And there's this thing called the cliff effect when it comes to SSI and SSDI. If I'm someone with a disability and I receive SSDI as my income, but I want to get out of the house, I want to get back to working, and I want to do some stuff, I risk my SSDI benefits by going back to work. I'm allowed to work a certain number of months before it starts to count against me. And then once it starts to count against me, there's only a certain number of months I'm allowed to actually work before I lose my benefits altogether. So I don't know what the formula is anymore. Back when I did this, this was, 18 years ago, 15 years ago, something like that. But it used to be something the equivalent of 3 to 4 years of part-time work / full-time work before you lose your actual check. So people with disabilities, they learn about this formula and they realize if I want to go back to work, but I also want to keep my benefits, which includes my Medicare or Medicaid, I can't work a full-time job. So by making a very conscious and intentional choice to work a part-time job, people with disabilities are going to be turned away from any housing community that has a rule that says you have to have a full-time job to live here. So it would disproportionately deny housing to these populations or this community of people. And because disability is a protected class, it would be a violation of the Fair Housing Act if discriminated against. So let me pause there. Is part-time workers a protected class? No. People with part-time jobs is not a protected class under the Federal Fair Housing Act. People with disabilities is the protected class. We have to draw the connection. We have to connect those dots. So because people who have part-time jobs correlate to people with disabilities, and it's more likely that people with disabilities are going to have part-time jobs, dots are connected. There we have the nexus, okay? Now we know that the rule of full-time work is going to disparately and disproportionately impact people with disabilities. I feel like just did like a geometrical proof. If A equals B and B equals C, then A equals C. That, that's kind of what we just did there. So the rule applies to all, and in practice, it has an adverse effect on a specific protected class more than others outside of the protected class. So let's talk a little bit about the history of disparate impact and how we got to where we're at today. And by the way, disparate impact is always growing. It's just like everything in law, it's living. Okay. In fact, just this morning, I'm working on a recent case that has disparate impact in its fact pattern, and I was researching updated case law and everything like that. So the cases I have for you today, more about the history of disparate impact, but we're constantly growing in this area. In 1971, Griggs v. Duke Power, it was an employment-based discrimination. And the Title VII prescribes not only overt discrimination, but also practices that are fair in form, but discriminatory in operation. So 1971, this was the kind of the introduction of the first concept of disparate impact, and it found its way through in an employment-based case. 6 years later, in 1977, in Dothert v. Rawlinson, the bona fide requirement, the business purpose question, we started to flesh out, we started to build the disparate impact litigation. So in 1971, we have the concept of, even though you didn't discriminate against me directly, I still feel that I'm being discriminated against. 1977, we have the business side of it. We have the business argument saying, I'm sorry that it had a discriminatory impact on you, but we had a business purpose for doing it. We're starting to build the litigation. We're building both sides. 12 years later, in 1989, in Ward's Cove Packing Company v. Antonio, now we're starting to get into the burden shifting, okay? So the business in 1977 said we have a reason for it. 12 years later, the plaintiff gets to say, okay, but you could do it a different way, okay? I recognize your business purpose, but I raise you an alternative solution, an alternative practice, okay? Or I raise, yes, you have a business purpose, but was it really a business necessity? Okay, we're starting to shift that back to or even though it's shifting the burden to the plaintiffs, you could even argue in 1989, you kind of shifted the opportunity back to the plaintiffs to keep the ball volleying back and forth. And in 1991, we have the Civil Rights Act of 1991. It codified the concept of disparate impact, but with limited specificity. So we're still very much dependent on case law and how the courts are interpreting disparate impact. But at least in 1991, it started to make its way into the law. Okay, it was codified and written into it. And then what's that? 24 years later in 2015, Texas Department of Housing and Community Affairs versus Inclusive Communities Project, Inc. Now disparate impact it's recognizable under the Fair Housing Act. Okay, so we've had disparate impact for, 44 years by the time it made its way into fair housing and enforcement of the Fair Housing Act. So if you ever do fair housing case law research, you're going to come across inclusive communities all the time. Okay, it's going to be very hard to do any sort of fair housing disparate impact based research and not come across inclusive communities. I highly recommend reading through it. It is pretty dense and very legalese, but it'll pull it all together. Okay. And so now most other areas of civil rights are now included. So the disparate impact theory applies not just to employment-based cases and not just to fair housing, but it does apply to most civil rights related areas of law. So I mentioned this word, the volley, okay? This is what disparate impact claims look like when they go to litigation. We're talking about burden shifting. There's a lot of back and forth, okay? So the first thing that happens is that the plaintiffs make the claim. In order to make a bona fide and prima facie claim under the fair housing, under the disparate impact theory and under fair housing, first you have to identify the facially neutral policy or practice. So example, when we go back to the idea that housing providers have a rule that says all potential tenants and all successfully applied tenants must have a full-time job, you have to identify that neutral policy. So to ensure higher probability of paying rent in full and on time, all tenants must have full-time employment. That's the rule. That's the policy. That's the practice that we're going to identify. The next thing the plaintiffs have to do is they have to establish the adversity or harm. So example, many people with disabilities engage in part-time work and supplement income via SSDI or SSI and participate in Ticket to Work program, and often due to disability are unable to work full-time hours, limiting their ability to qualify for housing under this rule. So as I mentioned before, sometimes it's a conscious decision because you don't want to lose your benefits. Sometimes it's just the reality of your disability. I go to dialysis appointments 3 times a week. I can't have a full-time job, or whatever it is that's the major life activity that's impacted by my disability includes my ability to work full-time. Because of that, I've established the adversity or the harm to me and people like me. Next, I have to establish the disparity. I identify the protected class. Remember, part-time workers is not a protected class. So you cannot go into court arguing under the Fair Housing Act that it's not fair to people who have part-time jobs, because the judge will say, I'm sorry, it's not fair to you, but they're not protected by this law. Go find a law that protects part-time workers, because the Fair Housing Act doesn't. You actually have to connect it to the protected class. That gets tricky, especially when you start to get phone calls from a lot of tenants who start to say, hey, we're all getting mistreated and it doesn't seem fair. I got a story, my neighbor has a story, the guy below me has the same story. This just doesn't seem fair. The job as the attorney is to find what's the protected class we're connecting the dot to. For example, a lot of times they'll say it's not fair because we're all smokers. Smokers is not a protected class, okay? It's not fair because we all work late hours. People who work late hours is not a protected class. You have to find one of those 7 protected classes to connect it to.
Joe,
yes.
may I interrupt so we can answer a question?
Okay, I found it here. So what are your thoughts in cases where LIHTC property requires minimum credit score for disabled client who receives a Section 8 voucher? Disparate impact? That's where my mind goes. So let's see here. It requires a minimum credit score. So it's a minimum credit. This actually might even be differential treatment just on its face. So if the LIHTC property is basically saying, because you have a disability, you have a different credit score you have to reach, that would just be differential treatment. You don't even have to bother with disparate impact. If they're saying everybody has to have a minimum credit score and that minimum credit score is, let's say, 550, I don't know, I'm making that up. Minimum credit score is 550 for everybody. people with disabilities are more likely to be below 550, then that would be disparate impact. However, if it's people who receive Section 8 vouchers are more likely to be below 550, we don't have it yet. Because people who receive Section 8 vouchers is not a protected class under the Federal Fair Housing Act. We could do one more dot and say people who receive Section 8 vouchers are more likely to have a disability. Okay, now we have it. We have to connect the dots to get to why are the people with disabilities the one that are being impacted. There might be 2 or 3 dots from the policy to the protected class, but we have to get there. So that's how I would respond to that one. If anyone else on the call, okay, good. If anyone else on the call has a different theory, I'm always open to hearing that. Okay, so let me go ahead and get back to where I was. Okay, so after you've identified the adversity, you establish the disparity, identify the protected class, and then you determine the significance of the disparity. You actually have to come early on with as many statistics, comparative analyses, and basically presenting why you are disparately impacted versus people who are not members of your protected class. Regional, national statistics, quantifiable, qualifiable evidence. It's not enough to say the 4 of us were impacted and we all have a disability. You have to say the 4 of us were impacted, we all have a disability. And if this policy remains in place, thousands of others are also going to be impacted. And here's the statistics that prove that, okay? Some of the best statistics are going to be the ones where your case was already litigated somewhere else in the country. Steal their notes. What happened in that case? Borrow those notes, borrow those statistics, because your case is just the next in line. And then finally, when the plaintiffs make the initial claim, they have to establish the causation. So you have to have the nexus between the policy and the actual adversity. The policy causes the disparity. It causes the harm. So example, the rule turns away people with disabilities at a higher rate, impacting their ability to secure housing, often leading to homelessness or segregated housing. So if that rule is implemented and you have 100 applicants and 50 of them have full-time work and 50 of them don't, there's a good chance that of the people who don't have full-time work, many of them have disabilities. So over the course of a time, that housing community is going to be filled with people without disabilities, leaving the people with disabilities without housing. That's the impact. You have to draw the connection between the rule and the cause and the harm, okay? All right. So now it volleys over to the other side. The ball bounces over the net, and now the respondent gets a chance to justify why they have the policy. They have to answer these questions. Is the policy legitimate? People with part-time jobs earn less money and are less likely to pay rent in full and on time. That's legitimate. It might not be the best solution. It might not even be a good solution, but is it a legitimate solution? I'm not a housing provider. I don't plan on being a housing provider. If a group of housing providers all started telling me at the same time, look, it's a whole lot easier to just make a rule that says you have full-time work, I believe them. It probably is easier. All it does is it makes it legitimate. Doesn't have to be the best solution. It's just a legitimate solution. Is it integral is the next question. Okay, now we're getting a little bit deeper. Is the policy integral? Receipt of full, timely rent to payments is the cornerstone of the business. Okay, it is integral if you're a housing provider to make sure you're receiving timely, fully paid rental payments. That's what you're in the business of. You rent space, they pay you money. And you have rules in place to make sure that they pay you that money on time. So yes, being paid rent is integral to your business. And finally, is it important? Without full, timely rents, they can't pay their employees, they can't make repairs, they can't pay the housing taxes. The business will fold if too many renters aren't paying their rent on time and in full. Okay, is it legitimate? Yes. Is it integral? Yes. Is it important? Yes. All they're trying to do is justify that they have a business reason behind it. This is not the stage where they're convincing the judge and the jury and it's the only solution available. They're just simply saying this is our policy and we can explain why we have it. You have to have a demonstrable relationship to the stated objective. Income directly impacts ability to pay rent. Okay, that's fair. You got me there. right? If you have a full-time job, you're more likely to have income that is going to cover your rent versus someone with a part-time job. That's fair. That's capitalism. The more money you make, the more money you have to spend on rent. Okay. And then finally, are there any special considerations, case by case, unique to development, region, era, et cetera? You, the responding party, may have a chance to come back and say, and in addition to it being legitimate, integral, important, and we can explain this, the demonstrable relationship to our stated objective, there's also something unique about our community. There's something unique about our region. There's something we learned in our experience that helped us develop this rule. And here's what that experience was. Here's what that situation was. You can bring those to court as well. So the business, the respondent party, the housing provider, they hit it back. They volley it back over the net, it goes back to the plaintiff. So now the plaintiff has the responsibility to say, okay, we hear you. You have a business reason for doing it, but there are less discriminatory ways for doing what you're doing. You have a purpose. Your purpose is to receive rent in full and on time, but your rule is not the only rule to make sure that that happens. So the plaintiff has a response showing that there is an additional method to reach the purpose. For example, lawful source of income can supplement income. If income supplement adds up to the equivalent of a full-time job, then the blanket rule of having full-time work is no longer necessary. Also, another example is a higher paying part-time job is just as good or better than a full-time job. You, the housing provider, your goal is to receive rent on time and in full. Your goal is not for me to work 40 hours a week. Those are two different things. Now, in our society, it's more likely that if I work 40 hours a week, I'm going to be able to pay your rent than if I work 20 hours a week. But if my 20-hour-a-week job pays me $500 an hour versus a 40-hour-a-week job that pays me $15 an hour, it's better that I have that part-time job that pays the $500 an hour. That's what you want, housing provider. You just want to make sure I have income that's going to cover the rent. So let's re-examine your rule or your policy, because I think that there's something else that could make it more applicable to what you're after. You have to show evidentiary burden. So full-time work actually does not guarantee full and timely rent, or statistics do not prove this assumption. So even though we can walk the court through how full-time work is not always better than part-time work, you got to bring stats. You got to bring that proof, okay? You have to show examples of when a part-time job is just as good or better than a full-time job, or just that a full-time job does not always result in fully paid and timely rent. And then you have to give the specificity of evidence of alternatives in relationship to the respondent's mission. Again, you say, housing provider, this is your purpose. This is your rule. Sure, your rule helps your purpose, but I can actually come up with a better rule, or I can give you specificity of evidence how a different rule is going to be better. So the best proof of full and timely payment of rent is most closely correlated to the amount of income, not full-time work, okay? A high-paying part-time job is better than a low-paying full-time job. You want to turn the rule on its ear. You want to turn it upside down and basically say there are different, and maybe not even better, but there are just different alternative ways for you to meet your purpose. Volley's back again. It goes back over the net, and it goes back to the respondent party. And I do want to pause right here. I don't have a slide for this because it's not applicable anymore. But 2 years ago, the Trump administration tried to make a rule regarding fair housing, or I think just general disparate impact arguments. They wanted the burden to stay with the plaintiff when it came to, I believe it was this point here, and if someone knows better than I do, please jump in, but I believe it was at this point, they wanted the ball to stay on the side of the plaintiff at this point. They tried to make a rule that took a lot of the burden shifting off the housing provider and kept it on the plaintiff. Once Biden, the rule was challenged in court, and then once Biden administration stepped in, they got rid of that rule. So we don't need to know the rule. We don't know the specifics of what that rule was going to do because it never really took shape. It was implemented, I think, for only like a month before it was challenged in court, and then eventually it was completely wiped away. So where we stand today is that the ball shifts back to the business, and the business has to say, okay, plaintiff, I hear your argument. you're right. There is an alternative method for me to meet my purpose. However, it's going to cost me too much to do that. Okay. You can come up with all the different solutions in the world, but at the end of the day, me, the business, I have to pay my bills. And if your solution costs me too much or doesn't result in me receiving the income that I have coming to me, we have to come up with a different solution. Okay. Because it's my wallet that's being affected if we implement an alternative solution. This is usually done on a case-by-case basis in the sense that it's the respondent party that gets to say, court, your honor, jury, if I was to implement the plaintiff's solution, here's how it would impact me. I would have to fire my, two of my leasing agents. I wouldn't be able to keep my maintenance crew because my numbers don't add up anymore. The burden falls on the respondent to say, here's why I can't do that. And it has to be backed by evidence. So in order to change my rule and or allow for new alternative method, respondent would need to spend or would lose an estimated, X number of dollars annually. So the respondent hits it, volleys. Oh, I'm sorry. There is one last one. I don't have the example for it. I'm going to go back to it. Yeah. So the respondent hits it one last time, and basically we see where the ball lands. That's what that in between slide is. That's where that last slide is. It's where does the ball land? Did you prove your point, respondent, that it costs too much? If you prove that it costs too much, you're likely going to win. If the argument of your cost burden doesn't hold up, you're going to lose as the respondent. Okay, that's that last volley. The plaintiff will have an opportunity to argue you did your numbers wrong, but for the most part, the respondent knows their business better than anyone. They know their books, they know how to do their own accounting, so they're the ones that get that final "it just doesn't add up" argument, and then we see where the ball lands. So this slide here I have, and I want to kind of open it up to the chat room, or I want to hear from people. We have some examples here of potential disparate impact rules. And so we're going to go through these one by one, and we want to hear from people, what is this potentially a violating rule via the disparate impact theory? And if so, what is the protected class that you think we could connect the dots to? So are each of these examples of disparate impact? And if so, who might be the disparately impact protected class in each of these scenarios? So the first one is no pets in the common areas. Applies to everyone, blanket rule. I'm sorry, if you have a pet, no pets in the common areas. Is this a rule that's potentially going to have a disparate impact on a particular protected class? And if so, which protected class? So I'm going to do the thing where I make it awkwardly silent until people start to put stuff in the chat box. Do we have any?
So we have, oh, that's Alexi's. Okay.
Come on, folks.
Well, Alexi says people with ESAs, and then we have another response, disability, service animals. Let's see, protected classes, disabled people. Edward. And then again, disability. So it looks like they've identified the protected class.
All right, yes. Yeah, that's correct. No pets in the common areas applies to everyone. Okay, well, what about people with emotional support animals? We were kind of hoping, fingers crossed, that someone in the chat box might have said no, because technically emotional support animals are not pets, but that's fine. It's fine that you didn't say it. Okay. Had the rule been no animals in the common area, then absolutely. No pets in the common areas. I have an emotional support animal. I don't care about your rule because I don't have a pet. I have an emotional support animal, but we're splitting hairs here. Yes, no pets in the common areas. It's going to impact people with disabilities who have service animals and emotional support animals. So even the rule doesn't say people with disabilities cannot come into the common areas. We can connect the dots pretty easily, and we don't even have to go one by one. It's pretty soon after we implement that rule that we realize, wow, in this common areas, I never see anybody with an emotional support animal. It's because they're not allowed in here because of the no pets rule. Okay. But the second one, rent is due on the 1st of the month, no exceptions. Is this disparate impact? And if so, who might it be against?
Okay, so we have a response, no protected class.
Okay.
Yeah, this is a tricky one.
This is a tricky one.
Yes.
We have disability again. Danita Jones.
Yes. So yes, we have.
I think so. I think we can make that connection to disability, and I'll walk you through what we kind of had in mind when we wrote this. Yeah, what about people who receive their disability checks on the 3rd? Yeah. I receive SSI or SSDI. My check comes in on the 3rd. My rent is due on the 1st. There it is, disability accommodation. The fact that the rule says no exceptions means I'm going to be late every month, which means I'm going to have to pay a late fee. So people who receive their SSDI checks, they're always going to be late. They're always going to incur penalties and fees. And if you're receiving an SSDI check, you have a disability. So we've made that connection. Now, people who receive SSDI checks is not a protected class. People with disabilities is, but those go together. Okay, that's an easy one to connect the dots. So the accommodation here would basically be saying, if you allow me to pay rent on the 4th, I'm not asking, can I be late? I'm just saying, can my due date be the 4th? That's where you can kind of implement that rule differently. If we were to do the volley, we're not going to go through the whole thing, but the business provider might say, well, no, because we actually have our bills and everything like that due on the 2nd. That's why we make it due on the 1st. Okay, that's a valid argument. You're going to have to go back and forth and kind of pick that apart. One thing that I do say here is, and I've heard this from housing providers, sometimes housing providers say, well, that's their problem. Just get ahead on your bills and then be early for next month. It's not the housing provider's place to tell someone how to manage their finances. If you receive your check on the 3rd, it's a whole lot easier. And remember the word burden. It's a lot less of a burden on the housing provider to say, sure, no problem, you can pay yours on the 4th, than it is for either the person with a disability to get 27 days ahead of their bills every month, or to contact the United States government and say, can I get my check on the 30th? That's not going to happen. It's a whole lot easier for the housing provider to just say, sure, you can pay yours on the 4th, no problem. All right, number 3, denying housing due to arrest records. How about this one? Do we have a potential protected class violation? Okay, we have no, so yeah, right away on the rule, there's no protected class identified. We haven't recognized here race, color, disability. So we're going to connect those dots. Let's run with that. If I have a rule that says if you have an arrest record, you cannot live here. Over time, my entire community, well, 85%, 90% of my community, it's going to be white people. The reason is because in the United States, yes, and people without disabilities, people without substance addiction, people without mental health disabilities. When we talk about race and color in the United States of America, statistics show that people of color have higher rates of arrest record. They do not have higher rates of criminal behavior, criminal activity. They have higher rates of arrest records. Anyone can get arrested at any time for anything. Everyone at the party got arrested that night. Wrong place, wrong time. I got pulled over for a speeding ticket. The police arrested me because of my skin color. That's not a reflection of criminal activity. It's a reflection of so many other things in our society. So if you have a rule that says that people with arrest records can't live here, it's only a couple of dots before you get to the idea that says, oh, we've had this rule for a year and now everybody's white. That's disparate impact. Okay, people of color are going to be able to point to the statistics saying there's no way we'll be able to live here because of the way history and society and injustice has treated us over the years, not because we have higher rates of criminal activity. And I love that people put in here mentally, people experiencing mental health, emotional health and stuff like that. And we mentioned before, substance addiction. So we've talked about this in previous presentations. Current substance use is not a protected class, but disability is. And substance addiction that you're working on, that you're recovering from, that you're going through, that's considered a disability under the Fair Housing Act, okay? So often enough, if you have a substance addiction that you're recovering from, it's likely that you have an arrest record, okay? A DUI or possession or something like that, okay? You're not gonna be able to rent at places that say no arrest records. That's gonna be a violation against your disability, okay? Even though the rule doesn't say no people with disabilities, the rule says no people with arrest records. And people with that particular type of disability are likely to have higher rates of arrest. All right, how about the next one? Denying housing to anyone with a previous eviction. What is the potential protected class that this might be disparately impacting? Race, okay, previous eviction. You could be evicted because you were on the receiving end of discrimination based on your race. Yeah, when we receive cases all the time for discriminatory treatment, it results in we're fighting an eviction, which means now that person has an eviction on their record. Okay, so yeah, you might be on the receiving end of an injustice, but you're the one walking around with the eviction record. Who else? Who else might have higher rates of eviction, and for what reason? This one's tricky. I'll go ahead and give it.
So
yes, please.
before you give the answer,
Yeah.
I do have a question in
Okay.
the Q&A box.
Yeah, okay. So if an arrest or criminal history is based on drug addiction, how would that be addressed with the housing provider? Reasonable accommodation? I am concerned about pointing out the previous drug addiction. So if it's coming up on a background check, first of all, if it's coming up on an arrest record check, housing providers shouldn't be doing that. They need to go deeper. The guidance now from HUD is strongly get rid of your arrest record rules. We've been told from HUD, start paying attention to those zero tolerance communities. Basically saying if you have an arrest record, we're going to deny you housing. They're starting to weed those out. And it's even getting to the point where they're saying even just simply having a felony record is not enough to deny someone housing. We have to go case by case. We really have to understand what was the person's criminal charge that they were charged for, pled guilty to, served time for, or whatever it was. The reason is this. Let's say state of Florida. Okay, let's say the business purpose for the housing provider having a criminal background check in the first place is safe communities. Okay, there you go, Christina, thank you. Let's say it's safe communities that the housing provider is trying to say, this is the reason for my criminal background check. In the state of Florida, it's a crime to drive without a license. And I believe once you drive without a license 3 times, it's a felony. If you're someone who is undocumented and you're raising your children who are born US citizens and you're driving them to school, you get caught driving without a license 3 times, you have a felony record. 15, 20 years later, for whatever reason, you're able to adjust your immigration status to a lawful permanent resident, you still have that felony record. That's not the person that the housing provider is trying to keep out. I mean, they might for other discriminatory reasons, but in the name of the business purpose of safe communities, it's not the mom who is driving their kids to school and got arrested for driving without a license. It doesn't go together. Safe communities doesn't connect to mom driving kid to school. So that's why it's encouraged that this whole criminal background check needs to be a case-by-case basis. So in response to the question, even though you're concerned about pointing out the previous drug addiction, if it comes up in a criminal background check and you can explain the criminal activity or the arrest or the charge because of a drug addiction, it's in the best interest to say, here's why I have it. I'm sober. I've been sober for 2 years, 3 years. I go to meetings, I go to therapy, I do everything I need to do. It is a disability. You are protected. If they say, wow, we were gonna say yes, but then you told us that you have a drug addiction, now we're gonna say no, that's violating your rights. If it's an active drug addiction, they can do that, okay? An active drug addiction is a safety matter, okay? Because an active drug addiction means drugs are being consumed on the premises. You can say no to that. A previous drug addiction is a disability. And while you might have concern and you might have caution around that, it's protected. So it might be a situation where you do have to step up and say, here's why. So regarding the previous eviction, yes, Christina wrote in the chat box, and then we have a comment from Alicia, absolutely. So if you're on the receiving end of a domestic violence event, and the landlord says, you know what, we're just going to kick everyone out of the house. We're just going to start fresh. The police came by last night. They took care of the issue, but all the other tenants were a little bit scared. They don't want you guys here anymore. So we're just going to evict everybody. You're evicting the survivor. You're evicting the person who is on the receiving end of the abuse. And statistically speaking, women are more often than not on the receiving end of domestic violence. That's why it's going to be disparate impact against women. If you have an eviction record, we don't want to talk to you. More often than not, you're going to be turning away women based on being evicted for being a victim of domestic violence. So the comment there from Alicia, survivors of domestic violence would likely have an eviction record, might even have an arrest record. Yes. Whether a disparate impact theory would be the best theory would depend heavily on the facts, though. Yes, yes, yes. That's where I think the disparate impact and domestic violence, where it's getting there. I don't know if case law has a clear line or a clear path for us, but HUD guidance and HUD training always goes to this and tries to say, or doesn't try, they clearly say, in our opinion, domestic violence and disparate impact are linked. But yes, you're gonna have to have the facts, the details, the statistics to back it up. Remember, and this gets tricky too, and we mention this oftentimes when we present to housing providers, and people listening, your legal aid attorneys, I'm sure you guys know this better than I do. When you're in a situation where you're the one calling 911 for your safety, more often than not, you're the one who gets arrested. The person calling 911 usually is the one who gets arrested. I don't know why every time, but I think the theory kind of goes like this, or if we want to try to make sense of that, if I'm calling 911 because I fear for my safety, I'm doing it from a safe room in the house. I've locked myself in a bathroom or a bedroom and I'm calling 911. My abuser is downstairs in the living room or on the front porch. The police arrive, they get to the abuser first. They listen to the abuser's story. The abuser says, it's fine, we're good. You know, we're just having a little argument. I don't know why she called you, everything's fine. And then when they finally get upstairs and they talk to the one who's being abused, they've already believed the abuser's side of the story. He's not getting arrested, she is. Because when things kind of get going and they start to, you know, decide who's right and who's wrong, it's more likely that they're going to believe the first story instead of the second story. So that's why an arrest record is often linked to someone who is the survivor of domestic violence. It's unfair, but it is the reality in a lot of people's stories. We've presented to a lot of domestic violence shelters, and we hear that story quite often. People raise their hands and say, I was the victim and I'm the one who got arrested. Yes, it's unfortunate. Let's see here. In the interest of time, we're going to skip over a couple of these last few ones, but there's a couple I wanted to make sure we pointed out. Some of these are pretty obvious. How about denying housing for failure to show proof of social security number? Might be an easy one. Any ideas? Who might this be disparately impacting? Immigrants, national origin, people from another country. If you're born in the US, you just get a social security number. You did nothing to earn it. You just simply won the cosmic lottery. You're born right in the United States. There we go, national origin. You're born in the US, you hit the cosmic lottery, they give you a social security number. People born outside of the US have to go through hoops and paths and roadblocks and obstacles to get their social security number. So if I'm a housing provider saying, sorry, we need a social security number to do your credit check and your background check, more often than not, you're going to be turning away people from other countries, which is national origin-based discrimination. The reason why it's important to bring this up, and as I mentioned at the beginning of this conversation today, is that immigration status is not protected, but national origin is. So you have to connect those dots. You have to be able to say, the more you implement this rule, the more you're turning away people based on national origin. Because the housing provider is very easily going to say, well, how am I supposed to do the credit check? There's alternative ways. There are alternative ways to do a credit check and a background check on someone. Passport ID number, a national consular ID number, a local sheriff's review of arrest records, a court review. There are lots of ways to do these checks without a social security number, but a lot of time housing providers just fold their arms and say, not my problem, okay? It is your problem if it's disparate impact, and that's what, you know, something that we're paying very close attention to. For purposes of time, I want to make sure people have a chance to ask some questions. I'm going to go ahead and skip the rest of these ones and just open it up to questions. So I don't know if I went too fast. This is a very detailed conversation, but hopefully there's a few things we could pick out. But feel free to drop some questions in the Q&A box or the chat box. Happy to answer any questions you have, or maybe you can even correct me. Maybe I said something wrong and it's killing you. Go ahead.
And while folks are mustering up their last minute questions, I'm going to drop the CLE code into the chat. That way folks will have enough time to write it all down. And something did come through. Do you want to read it?
Oh yeah, disparate impact with DV survivors. Anyone getting anywhere with FCHR? So FCHR refers to the Florida Commission on Human Rights. I'll let the tumbleweed go in front of the screen and the crickets with that question. Has anyone seen some good results or results at all? I know that there's a little bit of a logjam with some FCHR based investigations. I know from a lot of times when we send our complaints to HUD, they go to FCHR. I find that they just cannot understand the argument. It's a difficult conversation to have as far as making those connections. So remember, FCHR, they're the ones doing the investigation. They're not really, they do the investigation and then provide their findings. You can always take it further. You can even get a finding of no cause. So FCHR can say, we did the investigation and we just don't see it. You can still move forward to the administrative law or even a civil suit. But you're right. I don't know how best to answer that. I think it's anyone else. Yeah, I think all I can do is just nod my head to your question. I don't have a good answer other than, here we go. I would never expect a decent owner to sleep on this. FCHR. Yeah, I think, can you speak to the difference between service? Okay, yeah, Alicia, I went real quick. Yeah, maybe disparate impact claims. That's where we have to go to the, just civil suits and not go the administrative route. That might be the path for disparate impact. Question, can you speak to the differences between service animals and emotional support animals? I can just sort it. Okay, yeah, so service animals are trained and certified to provide a certain function for the person with a disability. So a seeing eye dog, or maybe a dog that is able to alert someone to medication, or Christina, what am I forgetting? Alarms.
The sounds, yes.
There we go. Yeah, sounds. There we go.
Knocking on the door, ringing of the telephone.
Perfect. Yeah, so yes. Service animals are trained and certified for a specific function. They come with certification. Now, the housing provider is not supposed to dig too deep, but if the animal comes with that certification, just be ready to provide it and say certified, trained for the specific function, and we have the nexus between what they're trained to do and my disability. An emotional support animal is not trained, not certified. They are simply a prescribed companion animal. Doesn't matter what animal it is, doesn't matter what kind of animal it is. Basically, the tenant says, this animal makes me whole. This animal is my prescription. The doctor prescribed it and you have to let me have it. So that's the biggest difference there. I see Alicia's comment. Going to court with disparate impact theory should be taken with severe caution. Yes, thank you, Alicia. Everything you're saying, yes. Yeah, I mean, we just spent the last hour talking about disparate impact. The next hour is, do we want to try it? Because yeah, it's a big endeavor. And we're talking years of your life. Yes. Any other questions? Yeah, oh, thank you, Christina. Yeah, service animals are limited to dogs and miniature horses. Emotional support animals can be anything. The only time they can turn away an emotional support animal is if it truly is a burden, but that burden cannot be defined as a big dog. The burden has to be defined as like an emotional support shark that needs its own, 100-gallon tank in the middle of a living room. Like that's when you're saying that no. But an emotional support snake, an emotional support alligator, you got to say yes to that as long as it's reasonable within the apartment living and it's safe.
And what I will do is when I send out, well, not I, but Zoom will send out an automatic email with the recording for this and the materials. I will also ensure that email includes our previous sessions that we had, because for folks that might have missed it, we had a really great session on everything you need to know about emotional support animals that might be helpful.
Yes, definitely. Well, let's see, I guess it's about 1 o'clock. So I just want to make sure I say thank you to everyone who participated over the last 4 months. We started this in the end of June. So thank you, Alexis. Thank you, Christina. Thank you to all of our attendees and people who have stuck with us. Looking at the participant list, a lot of familiar names. That's really fun to see. So thank you to everybody.
Absolutely. Yes, I echo everything that Joe said. Thank you all for coming along this ride with us. It's been a great ride. I mean, listening to Joe and Christina, it's some of my favorite trainings that I've had listening to you both. And yes, thank you so much to our audience who's been interactive, who's put your thoughts forward. It really just makes the presentations that much better. So TBD on another housing or fair housing or something related training series in the future. But for now, part 4 and the final part of our fair housing training series was approved for 1 general and 1 bias elimination CLE. I popped that code into the chat, but we'll read it out loud. It is 2207128, N as in Nancy. Again, you'll receive an email with that information, so don't worry if you don't get it before we sign off. So with that being said, I do see that someone just raised their hand, but I can't take them off mute. So if you do have any follow-up questions, please feel free to reach out to me directly, and I will make sure that Joe and Christina get that information, or I believe your information's in the PowerPoint, so they can maybe bother you. There you go. I can bother you directly. Awesome. Well, thank you, everyone. Stay safe in this storm, everybody, and we look forward to seeing you at the next training.
Bye, everybody.